And finally, what about the EU-UK's future relationship post-transition? What legal form will that take? The answer on the 20th of November 2020 is that we do not yet know. One possibility is another form of no deal, where the UK's trade relationship with the EU has no legal instrument underpinning it, no trade deal to ensure that products and services and data and components can cross the UK-EU border on a clear legal footing, except that part of the border on the island of Ireland, of course. Trading on WTO terms sounds nice and simple, but in fact, hardly any countries trade on this basis, so we don't really know what it would mean. What is entirely clear is that there would be significant and damaging disruption, both to the UK and to the EU, especially to those member states of the EU which are most geographically close to the UK. So the hope is that even at this late date, the UK and the EU can reach agreement on a trade and security relationship. The legal context for the negotiations are, once again, that the EU is a body of limited competencies constrained by the rule of law. If you've studied basic EU law, you're probably familiar with the idea of the EU's internal competence being limited. The European Union only has the powers that are given to it by the Treaty on European Union and the Treaty on the Functioning of the European Union, as formally agreed by all the member states and as interpreted by the European Court of Justice. But this is also true for the EU's external competences, the powers of the EU to enter into international agreements with other countries. Where there is no EU competence, power remains with the individual member states to enter into international agreements. The European Union's approach to the EU-UK future relationship negotiations has been to start from the position of existing agreements and to take the UK's stated positions very seriously. At no point did the EU formally accept that former member state is a special category requiring special treatment, which is probably a not inaccurate statement of the practical position, given the size of the UK and its geographical proximity to the EU, as well as its embeddedness in lots of EU supply chains in a whole host of areas. On the slide, you will see what is known as Barnier's steps of doom. Barnier, the European Commission's chief negotiator, presented the slide to the heads of state and government at the European Council, Article 50, on the 15th of December 2017. The slide shows 7 possible EU-UK relationships. These are real models in the sense that they are existing trade relationships between the European Union and various other states or groups of states. Achievement of the UK government's desire to enter into a deep and special relationship with the European Union is of necessity bounded by what is legally and practically possible, both for the EU and for the UK. Originally, it looked like the UK essentially had 2 options for a future EU-UK relationship: Norway and Canada. These are sometimes called a soft and hard Brexit. A soft Brexit, Norway, would have been where the UK agreed to comply with EU internal market law and could include all existing rights. But it would have involved the UK agreeing access to the single market, the integrity of which is a key principle of the EU's position for goods, services, capital, and crucially, people. This was an insurmountable sticking point for the UK government, as control over immigration became a touchstone of the way that the EU referendum result was interpreted by both the May and the Johnson governments. A so-called hard Brexit, where there is a negotiated withdrawal agreement and then a future EU-UK relationship based, say, on the EU-Canada trade agreement, might not involve any aspects concerning free movement of people. It would open up trade in products, so long as non-tariff barrier matters could be agreed, and in services, but probably with significant exceptions. There would be a need for checking of products as they arrive in the UK. It could possibly involve some regulatory alignment to allow products to be produced for the EU and UK market, for example, pharmaceuticals or food. But to do this would mean that the UK would not be able to benefit so easily from trade deals with other parts of the world, especially the USA. What the UK wants can be interpreted as a cake and eat it, or imaginary sparkly unicorn Brexit. So we see this in the September 2017 Prime Minister May speech in Florence, deliberately vague on the future EU-UK relationship. May explicitly rejects both soft Brexit, Norway, and hard Brexit, Canada. The imaginative new relationship of that speech is to be based on domestic democratic control. So already we see a disconnect between this position and principles that sit behind the way that the EU interacts with its closest partners, those countries in the European Economic Area. But May also rejects hard Brexit, Canada, recognizing that it would nevertheless represent such a restriction on our mutual market access that it would benefit neither of our economies. Barnier, in response, talking to the press on the 24th of October, said that no bespoke deal for the UK would be available. And given May's position on the single market, what could be done would be more like Canada than Norway. Now, this conversation has happened essentially on a repeat loop since then under both the May and the Johnson administrations. It is a matter of choices. The profound pooling of sovereignty that is a crucial feature of the European Union permits unprecedentedly deep cooperation, which brings benefits. But it also means that when countries are in the minority, they must sometimes accept decisions they do not want, even affecting domestic matters with no market implications beyond their borders. And when such decisions are taken, they can be very hard to change. This is at the heart of critiques of the European Union and how it undermines domestic choices about cultural or social matters. So the choice being made by the UK electorate has been interpreted as a choice of domestic democratic control, along with all its downsides as well as its upsides, over pooling that control. There is, after all, as they say, nothing new under the sun. There are only old things that we do not yet know. And yet, maybe this isn't only in the land of pink sparkly unicorns. A bespoke Brexit might be the only way politically that the future relationship between the EU and the UK can be achieved or conceptualised. This may not have any systemic aspects at all. Rather than a relationship, it could be based on a series of relationships in the plural, all governed by ordinary international law. We can legally conceptualise this. These agreements exist between the UK and other countries, and to some extent between the EU and other countries. This is what the UK White Paper on the Future Relationship proposes. And this is what is embodied in the UK's negotiating documents, at least those which we have seen. The EU and the UK formally began negotiating their post-transition future relationship in March 2020. The EU negotiating position is adopted in Council Decision 2020-266, which states that the EU is negotiating on the basis of powers given to it in Articles 217 and 218 of the TFEU. More on that in a minute. After all, we can overstate the notion that the EU is a rules-based system. There are plenty of examples of what Deirdre Curtin first named as an EU of bits and pieces, based on political expediency and practicality rather than legal principle. The European Union has always held in tension integration and diversity. So maybe we need a new legal conceptual framework to understand this, what Professor Joe Shaw has called an ever looser union. The European Union's external competence, which governs the EU's powers to negotiate its future relationship or relationships with the UK, is set out in the Treaty on the Functioning of the European Union. According to Article 3(1)(e), the European Union has exclusive competence in its common commercial policy, the policy that determines the basis on which the EU trades with the rest of the world. Article 3(2) also gives the EU exclusive competence where an EU legislative act provides for the EU to conclude an international agreement. In other aspects of external relations, the European Union shares competence with its member states. When this is the case, the agreement is called a mixed agreement, and it has to be ratified by the European Union and by each of its competent member states, in accordance with their constitutional requirements for ratifying treaties. Opinion 215 of the Court of Justice of the European Union on the EU-Singapore agreement gave us some good clues about whether the EU-UK agreement needs to be a mixed agreement. Here's some analysis of that from the Monkton Chambers blog. In that Singapore case, the Court of Justice of the European Union found that most of the matters covered by the agreement fell within the exclusive competence of the EU, including access to the EU market and Singapore market for goods and services, public procurement, and energy generation from sustainable non-fossil sources, including protection of direct foreign investments of Singapore nationals in the EU and vice versa, including intellectual property, competition and subsidies, sustainable development, and rules about the exchange of information, notification, verification, cooperation, mediation, transparency, and dispute settlement, except in connection with non-direct foreign investment. However, the court found there to be two areas covered by the agreement where the EU has shared competence with the member states, meaning that the agreement in its current form could not be concluded without the member states' involvement. And these were non-direct foreign investment, portfolio investments made without any intention to influence the management or control of an undertaking, and investor-state dispute settlement. Why does this matter? Well, it's a matter of considerable legal and practical significance. If the EU is exclusively competent, the agreement would be concluded by the Council alone with the consent of the European Parliament. If, on the other hand, the agreement was a mixed agreement, it would be concluded by the Council and every member state ratifying the agreement in accordance with their constitutional procedures. This process may not be smooth. The conclusion of the Comprehensive Economic and Trade Agreement between the EU and Canada, known as CETA, was nearly derailed when the Walloon Parliament in Belgium in October 2016 refused to assent to the agreement. The European Union's negotiation documents suggest that the EU has left it open whether it is a mixed agreement or not. The relevant Council decision is based on Article 217 TFEU for the trade aspects of the relationship and Article 2183 TFEU for its security aspects. It is not based on Article 207 TFEU, which would have signalled that the EU is clear that it had exclusive competence over the agreement. Both the EU and the UK have published their draft negotiating texts. The EU is seeking a new partnership agreement with the UK, which will be treated like an ordinary third country with which the EU has an association or partnership agreement. The UK is seeking a comprehensive free trade agreement along with other separate agreements. There is quite a lot of common ground between the two positions, but also several crucial sticking points, including the so-called level playing field, fisheries, and governance and enforcement. Level playing field means rules to make sure that UK-based businesses don't have an unfair competitive advantage over EU-based businesses and vice versa. That kind of advantage could arise from different rules on workers' rights, environmental standards, or financial aids given by the government to business, also known as state aids to industry. I'm not going to say too much here about the negotiation positions because either there will be an agreed text soon, and then there will be another lecture about that, or there won't be, and we'll be in the cliff edge of no deal again. So what will happen next? Well, obviously the UK left the EU on the 31st of January 2020, and the transition period ends on the 31st of December 2020. If there is no EU-UK agreement by then we are in no deal territory again, with all the disruption entailed. The disruption will be less than it would have been in March 2019, though, because both sides have put some contingency measures in place, but it will still be significant. So, what to take home from all of this if you're studying European Union law at the moment? The number one take home from me is that the law matters. Sure, Brexit is a political and social and economic and cultural event, but it is also a legal event, and the legal contexts are important drivers and constrainers of the process, as well as resources to be used to achieve political or social ends. Here, the difference between the European Union and the United Kingdom is really stark. The UK's constitution gives a huge amount, many would say too much, practical flexibility. But the EU's quasi-constitution gives flexibility only within certain constraints. These constraints are both substantive, but more importantly, procedural. The EU has to operate through the procedures established in the treaties. It cannot, for example, adopt an EU-UK agreement without the consent of the European Parliament. If it did, the agreement could be struck down by the Court of Justice of the European Union as non-compliant with EU law. The oversight of the Court of Justice of the European Union secures that position of the European Parliament as a privileged applicant under Article 263 TFEU. The European Parliament could, if necessary, legally challenge an agreement that it had not given its assent to. So we could say that Brexit is an important case study in the strength of the EU as a rules-based organisation. Thank you very much for listening to these lectures, and if you have any comments or want to discuss anything, please do get in touch with me by one or other of the various means indicated here and on the lecture slides. Just to finish, a few points of further reading here. These first two have been written by me in collaboration with some really excellent student interns at the University of Sheffield. And here are some books that I think are particularly useful legal insights on the process of Brexit. Thank you.